should be okay. All right. All right. I think it's starting pretty soon. Thanks. Okay, Louis. All right. Bye. Morning, Andrew. Are we live?
Morning.
Louis should be coming on as well right now.
Okay.
We have had some difficulty working with this in the last couple of days, but if he had to use the phone dial-in option and just speak on the phone, does he need any special permission or to be let in?
No, it works essentially the same way. Like I'll get a prompt when he's gonna dial in. So yeah, I mean, and I believe Judge Booley is signing on right now also. So we could ask Judge Booley if he's okay with him appearing by phone.
The video should work though. They said they were waiting. They had the waiting
Okay.
screen up.
Good morning.
Morning, Judge.
We have some
Morning,
technical. We have some technical issues. Estella and Katie are only appearing by way of, I believe, their cell phone. I don't see that as a problem.
I'm here, Judge. Katie is just getting connected.
Okay.
Hey,
So I
Jim.
heard you gentlemen talking that Mr. Taylor has he's going to appear by video. Is that correct, Mr. Voorhees?
I believe so. My last contact a few minutes ago was he was waiting for the host. So I thought everything was set, but I'm going to mute my mic and check my calling there right now.
Sure.
Okay. Oh, we're connected on the court thing.
Hold on. Oh. I think we will be able to connect here.
Good morning, everyone. I'd like to ask to just keep my camera off. I'm having some bad connection, so I'm trying to mitigate me getting kicked out.
That's fine, Ashley.
Thank you.
What are you doing, Leah?
Doing well. I'm preparing for the deep freeze that's happening over here.
So as you're preparing for that, I just want to pass on a message that my friend sent me who lives in Alaska. They've been hanging around 60 below for a couple days now. So we're not too bad.
Right.
Although we're supposed to get 20 below, I heard that. That's cold.
Yeah, I think 20 below here on Saturday is what they're forecasting.
Yeah. That's squeaky snow.
Hello, Judge and Andrew.
Yes.
Andrew, I have Louis and one of his daughters on the phone, and they said they were still waiting for the host. I sent him the previous link. We're using the same link today.
I believe so. Here, I will. I'll send to you, John,
Judge Boley, can you hear me?
Yes, I can.
Okay.
Hello, are you there? Hello? Is this Ella? Just a second.
You guys have much going on there?
It snowed pretty good yesterday, Judge. I think we got like three inches of snow or so in the Twin Cities. And then last night, you know, the clouds broke up and it got kind of clear, and then the temperature dropped. And yeah, I think the high here in the Twin Cities today is only supposed to be about 9 or 10, and then the floor kind of falls out tonight, and we're gonna get our annual you know, week where the high doesn't get above, you know, 0 by much. So it's a good thing. My two boys each knocked a deer down during the youth hunt this past October. So we'll be able to, I won't have to leave the house much to go get groceries. So
It's called winter, right?
yeah.
We've had a pretty mild winter, so there's no complaints.
Yeah, we have had a mild winter. I mean, I think I've only run my snowblower once, twice so far this year, which is, you know, there hasn't really been a lot of snow, at least down here in the cities.
And although the covering is nice right now with the cold weather coming in, because I remember in my younger days, we didn't get much snow in winter, but we got a real severe cold snap. And it was like taking out sewer lines all over the place, among other problems.
Yeah, the snow covering's nice right now in the Twin Cities, at least. So
See Lewis on there.
mm-hmm.
I think they are there, Judge. Can I ask them to start the
Please.
video? Lewis, can you hear me? Ella and Lewis?
Can you hear me?
Yes, I can see you too.
No.
Lewis, can you hear me?
I hear you.
All right. All right, we're ready to begin. Are you ready to begin?
Yes, say yes.
Yes.
Okay. All right, the case, please.
The case today is in the interest of the St. Croix tribe versus Lewis Taylor. Case number 20-CV-209. Presiding today is the Honorable Judge Stephen Booley. The appearances for the record, Your Honor, are tribal attorneys Andrew Adams, Ashley Duffy, and Leah Jers. The defendant, Lewis Taylor, along with his attorney, John Voorhees.
Okay, call the court to order. The court had granted a request for default judgment on Tuesday. We set this time aside to go over the final order. Mr. Voorhees had asked that I would give Mr. Taylor an opportunity to speak, and I granted that. So in the meantime, I had received a proposed final judgment in order from Mr. Adams. Mr. Voorhees, have you had an opportunity to review that?
Judge, I have reviewed the proposed final judgment in order, and I advised counsel for the tribe yesterday that I believed it was appropriate in form and had no objection to it. There's still a blank for the amount of restitution to be ordered by the court.
Right. Okay, so what we're going to do today, I'm going to ask Mr. Adams to give me a summary of what the final order says. Mr. Voorhees, I'll give you an opportunity to speak to that, and after that, I'll give Mr. Taylor an opportunity to address the court. Mr. Adams?
Good morning, Your Honor. So as you stated, you asked the tribe to provide a proposed final judgment in order, in the case, and the tribe drafted a proposed order. We provided it to Attorney Voorhees for his review and for consultation with his client. The proposed order discusses the 10-count complaint that was filed against Mr. Taylor. We originally had a trial scheduled to begin at 9 a.m. on February 2nd. But as the court is well aware, Mr. Taylor had concerns regarding his Fifth Amendment right against self-incrimination, and so did not appear. At that same time, the tribe made an oral motion for a default judgment, which was not objected to by Attorney Voorhees, and so under Section 311 sub B of the St. Croix Tribal Court Code, the court has the authority to issue a default judgment where a defendant fails to appear, and the court granted that at that time on the 2nd. And we're here this morning to discuss the wrapping up of the final order. And I believe, don't want to make any assumptions, Your Honor, but believe that, the court may want to take into consideration the requested restitution amount of $211,418.64 that the tribe is seeking for the checks that were cut to Mr. Taylor. And then the tribe is also asking for its attorney's fees in the amount of $22,080. And I believe that there are, the proposed order has $300 in court costs, and just want to, confirm with the court that those court costs are accurate. And Your Honor, to ask the court to issue the final judgment in order in the case.
As to the court cost, that's accurate. Is there anything else you want to add?
I mean, not at this time, Your Honor, unless there's specific issues that you would like to discuss. But, you know, based on the stipulation that the parties entered into and the court's granting of the default, the motion for default judgment from the second, I mean, I believe at this point, Your Honor, I mean, the tribe doesn't have to put on, you know, any more of a case. And at this point, I think it's just a discussion concerning restitution and then allowing, you know, Mr. Taylor to address the court.
Okay, Mr. Voorhees?
Judge, I have nothing further to add regarding the judgment, although, as I indicated previously, I would ask the court to consider some amount or some degree of restitution credit, or recognize some amount of shared responsibility, or what I might call mitigation. I'd like to summarize some of the background regarding Mr. Taylor for the court, because I think it could be relevant now and maybe in the future as well. But without a trial, the court has not had the benefit of a lot of details about Mr. Taylor's life. But I'm not going to go into a lot of detail, but if okay with the court, I'd like to advise you that he is 76 years old. Mr. Taylor does reside in Hurdle in the Sand Lake community as tribal housing. He resides in a home with his wife, Lisa. They have placement and guardianship of 7 children under the age of 18. Those are all grandchildren of his. Mr. Taylor does have, I believe, 4 adult children, but I may not have the exact number. But he's been a backstop for this family, and I think he and his wife are doing a good job raising these children. They're all enrolled in school. They're all seem to be polite. None of them are in trouble. I don't think they're experiencing significant social issues at this time, and they're very polite and helpful to Lewis. Lewis himself has some significant health problems. He knows I'm going to mention those today, but he has had significant diabetes problems, including infections on several occasions. He's been septic in the last several years. He and his wife both talk about the seriousness of his health problems over the last 4 to 5 years, where he's had 4 surgeries for amputations, and I think it's compromised his ability to handle a lot of his responsibilities. But he's still alert. He's easy to talk to. He's been cooperative with me throughout the proceeding. I think the court should recognize, or I think you do understand, that his assertion of an invocation of the Fifth Amendment privileges here are reasonable, and I think based on some realistic risks, although I don't want to exaggerate them, and I hope the court doesn't draw too many adverse conclusions from them. We have a significant factual record here, and obviously the part of this case is checks issued on an account referred to as the St. Croix Casino Turtle Lake EDC checks. And Mr. Taylor is accepting responsibility for all those checks. He has acknowledged that he received those checks. A lot of them were cashed at his bank, but others were cashed at other locations, including the casino, which is an obvious advantage to, I guess, the St. Croix tribal member when they have a big check to cash, and many of these were. He was able to do that within the community at the casino. The stipulation recognizes, and Mr. Taylor recognizes some significant liability here. And I think the court is fully aware of the NIGC notice of violation, along with the initial proposed civil fine assessment and the settlement agreement that finally resolved that case between the NIGC and the tribe. I don't think it's necessary to go into a lot of detail regarding the problems or even the behavior of Mr. Taylor that got us to this point. But I want the court to understand that Mr. Taylor, in a number of conferences with me, has expressed remorse. He's extremely embarrassed about his role in this. He takes responsibility for that, and I think the stipulation and the resolution of this case shows that as well. But the documents from the NIGC that are also in the record clearly also show that the tribal government had some responsibility for letting a situation develop that, and I'm not blaming the tribe, because again, I think Mr. Taylor, because of his position as a tribal council member, and he was a tribal council member throughout the period of time in question here, but he also served on this tribal council over 20 years, except for some terms over 10 years ago where he was not in elected office. So he's very familiar with the development of gaming and other activities of the tribe. He has signed some of the documents relevant to the tribal gaming ordinance and the compacts. He's he should have done better, should have had a better understanding of things, but the essential allegation of the NIGC that is the 527 counts that they referenced show that there was significant widespread misuse of the net gaming revenues, and there's certainly been an emphasis on what in the settlement agreement is referred to a couple of times as ad hoc payments by the casino. In Lewis's case, mostly for travel, although there were also 6 miscellaneous disbursements that figure into this case in an important way. But it was a situation where I believe from the record you can tell that the tribal government was facing economic issues, put restrictions on travel. The tribal government, far as I know, was not working with the casino to allow individuals to skirt tribal regulations, but the casino was available as a source to fund all kinds of requests. Some may even appear to be kind of legitimate transactions where the tribe, if they had efficient programs in place and find eligibility rules and guidelines, policy, they probably could have assisted some of the ways mentioned in some of these cases. In Lewis's case, most of his disbursements are travel, and he did, and I think it's a fair inference from the record here that he did travel extensively for the tribe, attending conferences. About although there's 83 travel checks involved here, I think a good assessment of what happened was there was probably about 18 of these travel trips. Most of them also parallel interstate checks that were issued for travel, but they show multiple disbursements for the same travel. There's 18 examples of that, where there was 2 or sometimes even 3 or 4 checks issued for the same trip. There was about, I think it's fair to say, about half the trips were out-of-state trips, and they are subject of a lot of the significant relatively high disbursements from the casino. But there was a practice in place, even with tribal travel vouchers, where the tribe typically would pay flat rate advances to individuals traveling on tribal business. And they would, as a matter of course, offer travel stipends or per diems that are above actual anticipated expenses. And a lot of those, for example, for the in-state trips, Mr. Taylor received a $1,000 travel stipend, sometimes referred to as extra travel, from the tribal interstate department. Transactions that are not really just not the transactions the tribe is seeking restitution on right now. And of course, that same kind of practice through the casino was even probably more aggravated, but certainly I think, as it's characterized in the complaint, excessive, especially in those situations where there's multiple disbursements for the same travel. But there were plenty of examples here where Mr. Taylor was compensated well beyond actual expenses for the trips to Las Vegas, to Phoenix, California, really all over the country now. There is some reason to believe that traveling for the tribe, whether it's for conferences, for training, specialized training at times for taxation seminars or money laundering, Title 31 examples, a lot of participation in the big conventions referred to as, for example, the Res 2015, Res 2016, Res 2017, usually Las Vegas trip, G2E conventions. I think it's reasonable for the court to draw some lines here and recognize that the amount of travel was excessive for Lewis and probably for other tribal council people in this case. And he hurt himself, I think, and I think the entire tribal council, as the governing body, hurt themselves by not putting in place some kind of checks and balances or some kind of internal controls. And I don't have any good explanation why this abuse occurred. And I recognize that in business, employment, and other fiduciary situations, it's the trust of everybody and their good faith and their goodwill that are important, and those things were violated here. And Mr. Taylor did work for the tribe as a tribal council member and chairman for many, many years. I think he did assist in some of the economic development projects that the tribe did here, but in the end, it's a sad story, but it's but I wish I could explain it away, but I simply can't. But I would ask the court to recognize that there were many years of actual service to the tribe, and there was actual travel, like I indicated, at least 30 in-state trips and more than 30 out-of-state trips that are reflected in these particular checks. And I think there should be some degree of accepted responsibility by everybody, and the tribe has certainly done that through the settlement agreement and the hard work that they have to go. But the lack of controls, the lack of training, the lack of understanding among a lot of the tribal officials and individuals here, including Mr. Taylor, shows a number of deficiencies that we all wish had not existed. Now, at this point in time, Mr. Taylor does not have significant financial means, in my opinion. He doesn't have any kind of pension because he was in elected office for years. He didn't save a lot of money. I'm getting an indication my connection might be unstable, so if you can't hear me, let me know, please. But he does have Social Security. He has Social Security of about $900 a month. Family also receives some kinship care for assistance in raising the children, and that's $200 and some a month. Don't think that he has significant assets that are in a property or a home in Siren, but I think there's some tax liens that compromise his ability to pay anything from that asset. I would offer to the court that Mr. Taylor would be willing to certainly pay over his per capita, and he's willing to pay over and above the amount that the tribe revenue allocation plan. I think there's some reference to that, or it might be in the tribal code, but so we can make some payments of several hundred a month. I would ask the court to maybe also consider some community service. His health may limit him, and during times of COVID, I don't know what he can do, but he would like to assist some Ojibwe and Anishinaabe language programs. The language is important and tradition is important to, in addition to that, I would ask the court to consider keeping open and possibly ordering some type of restorative justice as a condition of the judgment in this case. Something along the lines of peacemaking courts that exist in the long run. I think that it would benefit possibly Mr. Taylor needs a better forum to really deal with the tribe and its problems. What's happened here has been something that it is extremely embarrassing to him, and knows that there's been lack of decision making and abuse of the fiduciary responsibilities. I think it would be a benefit if he could participate in some kind of restorative justice. Along those lines, I have contacted a couple of former judges, tribal judges that I know of that are trained in that area. I know there's others around the state. The tribe's willing, and something can be set up in the future when pandemic seems to be a little bit better under control. I think Mr. Taylor is willing to participate towards a little more, restore a little more harmony and thing. And I'm not asking necessarily for restitution credit for that, but I think it's a showing of Mr. Taylor's good faith and his desire to try to give something back. And I certainly hope he can do that. Thank the parties in the court for your cooperation with us in presenting the case. I know it hasn't been a perfect resolution when you don't hear testimony about all the details of these transactions. But I would ask the court to consider some amount of generosity towards Taylor in fashioning the judgment. And I think he would like to make a statement to the court as well right now.
Okay, thank you, Mr. Voorhees. Mr. Taylor, are you prepared to make a statement to the court?
Thank you. Your Honor, in behalf of myself, my family, in the 30 years of the longest elected official for the Sacred Tribe, I really have a lot of mixed feelings, particularly, in this legacy I created. It's very hard for me to go into the community and I'm just, I'm embarrassed as to what happened. And obviously, I take, I'm very compassionate when it comes to, the things that I created. And yet, the many travels I went on to. But Your Honor, I was also a lobbyist. And I was the primary lobbyist for the tribe. And, when you go to meetings, a lot of people would say, well, let's go to dinner tonight and we'll discuss this. And, I had to pick up the tab. So, it was very expensive. And I was thankful that I did have extra, extra money that the tribe gave to me. but in all, in any event, as you say, I have limited income today. One of my goals that I wanted to achieve for the tribe was to put a good retirement plan in place, and that went back on the back burner because I didn't have support from some of the council members. So, it was just some years were very difficult to work with the council. But again, in my life today, as I'm in hospice, I do, my health condition is not the best, but I've been diagnosed with hospice. I'm under hospice care, and but needless to say, my priority in that is raising my grandchildren. I love my grandchildren, and today we're in quarantine. Fortunately, I got a shot prior to the kids getting this COVID. So for me, I in terms of of interaction with my children, you know, we're very, you know, we isolate them very, productive manner so that we don't all get COVID. But again, uh, we have to make use of what we got, and definitely, being who I am, and how to address this and how to combat this spread of COVID within our own house. I mean, we're achieving it, and next week we'll be out of this quarantine. But again, this virus that came about, affected my family. So again, and I think as far as uh, as I say, the legacy, the 30-year legacy I had with the tribal, with the tribe as the longest elected official on the tribe. I mean, it is kind of embarrassing today when I look at what how it ended. But again, I really I'm sincere. I apologize. I'm very I just want to say that as life goes on, my priorities, my raising of my children right now, we do have as a lot of members, and particularly my family, we have some damaged children, and as a result of that, I got permanent custody of my grandchildren, and uh, am I working with them to try and reunite as families? Yes, but the outlook is bleak. They're just not. The drug addiction is very, very. It's a cruel tool when a person sees it as I see it, and it's just obviously I need to I need to raise my grandchildren, and I'm committed to do that. And again, because of limited resources, I do have, I still have, I have the true love for raising these kids, and I really, but anyway, in concluding in conclusion, I just say, I'm very sorry that this had to happen. I I would like to express that the court take in consideration my role as a lobbyist, and achieving, you know, from a from a so when I was first elected, our tribe was we were dependent on handouts from the government. Today we're quasi independent, and we're on the verge of being self sufficient. And again, those those as, those progressives that we have as Indian people, I was proud to see that we have some stable economic development projects. But again, I'm very shameful that it ended this way. And with that, I want to say uh, I'll definitely uh, express that in consideration of the things I've done, how I achieved progression with the tribe, and at the same time that it was very expensive to do what we had because of lobbying, and committed to uh, having meetings over dinner, and dinner was not cheap. But I want to thank you for listening to me, and thank you very much.
All right, thank you.
Thank you.
All right, I've heard what you guys had to say. Um, It's very clear to me what the tribe's asking for. The defendant has made a request for leniency. I'll take it, there's no other way than that. They've also made a request to be able to perform community service. From the point of community service, I'm going to grant that. That would need to be worked out between the defendant and the tribe, but I'm going to allow community service. And the amount of the community service per hour will be, again, something to be determined by the tribe. I've had the pleasure in my life to know some pretty good people who've done some wonderful things for the tribe. I'm not talking just about St. Croix. And I've also had the sadness of watching that whole legacy disappear by just a couple of poor decisions, poor judgments. The tribe here isn't asking for anything other than a restitution. They're not asking for a penalty. They're not asking, okay, let's fine Mr. Taylor whole X amount of dollars because of his wrongdoing or his errors in judgment. All they're doing is asking for his restitution for those amounts of money that were improperly obtained. Mr. Taylor was in a position when he was a chairman and otherwise on the council to adjust his matter more appropriately if he knew what it meant. But that would have been, in my opinion, something that he should have done. He should have made himself aware of what was going on and used the people that are around him. He had access to numerous of attorneys who could have informed him about the legality of what he's doing and the impact of his decisions. So I'm not going to modify the amount that the tribe's asking for. I'm not going to modify the amount of the court cost. I'm not going to modify the amount of the attorney's fees. As far as my understanding of the garnishments, the tribe wants to garnish Mr. Taylor's anything that they can garnish from him. There's a limit on that also. I believe that limit is 25%, and that would be, then the rest he could use for caring for his grandchildren and for his family. So we're not taking all his money away from him. I'm not very clear on the restorative justice idea. That seems to me that though that would need to be brought up at a different time in a different manner. That would also probably require the tribe to have a level of agreement there. And again, as I said previously, and I'll say it again, Mr. Taylor's legacy right now, if he focused just on this particular point, would be a poor decision in a line of a whole lot of good decisions, because he did some things that were positive. Down the road, if there's a way that, again, this seems that this would be where restorative justice may step in and be able to help out. Again, I'm not a whole lot familiar with it. I've kind of heard about it, but I haven't studied it or looked into it in any depth. Again, that's something that would need to happen down the road. That's not something that I'm going to take up today. I'm just saying that that's an option that you guys can look at as you go down the road, and you can go from there. All right. So the bottom line is this, the restitution for the amount of $211,418.64. Mr. Taylor owes that. The attorney's fees of $22,080, $22,080. Mr. Taylor owes that. The amount of the court costs of $300, Mr. Taylor owes that. The court is going to allow Mr. Taylor to perform community service to meet that amount. He would need to contact the tribe and work out an agreement about what to do. I understand Mr. Taylor has some physical limitations, but as he said, he also has some gifts and things that he can still offer to the tribe. And I would encourage him to do that. That may even be a path of restorative justice. Let's start working on these things that's going to get you back in contact with your people. I'm probably looking at you talking about a language table, those kinds of things. Those are always where you're well versed. It's always worthwhile pursuing those things to help with the tribe. The other thing I need to issue though as an order is that because of this conviction, you will no longer be able to run for political office. So that's where I'm going with that. Okay. All right. Mr. Adams.
Yes, Your Honor. When it comes to the community service, Your Honor, we would. I don't know how easy or difficult it would be to come to, some type of agreement concerning the hourly, the monetary value of the per hour, each hour that Mr. Taylor were to serve concerning community service. So I would ask that the court consider to just adopt the current prevailing rate as set by federal law. And to be honest, Your Honor, that amount escapes me right now, but that would be an easy way to settle the amount, like the dollar amount per hour that would be ascribed to each hour that Mr. Taylor performed in community service. And I believe it's somewhere in the neighborhood, Your Honor, of about $25 per hour, somewhere in that neighborhood, $20 to $25 per hour. And would be curious to hear from you, from the court, Your Honor, if the amount is unlimited or if there's a certain, threshold that you would like Mr. Taylor to, to meet. And I guess the only point that I would add to that, Your Honor, is that the tribe is not looking for any type of minimum requirement. I mean, if the court wants to make it unlimited and open-ended, I mean, we don't have any objection to that. I guess just the biggest consideration for the tribe is the mechanism by which it would be monitored, in terms of who, because if we were in a federal court or a state court, there would be an apparatus set up for kind of tracking, the amount of hours that Mr. Taylor would provide in terms of community service. And just curious how the court would like those hours to be tracked.
Okay, well, my experience with community service, and I've had some experience with community service, some, not a lot, some, but it would be Mr. Taylor's, there'd need to be agreement between Mr. Taylor and the tribe about what he could do. Once they've come to that agreement, then they would need to come to an agreement about the hours he's going to put in per month. Again, Mr. Taylor can say he's going to do 40 hours a month. As long as his health allows him to do that, fine. But if his health doesn't allow him to do that, you guys would need to be flexible with him on that. Then any community service that he would complete would be deducted from the amount of money that he owes the tribe. But the court costs, I'm not opposed to Mr. Taylor working off all the debt that he owes the tribe. But I would say that he has to pay the court costs. And he also has to pay the attorney's fees. So those need to be in dollars and cents. As far as the restitution though, I'm open to him working that entire amount in community service. As for the rate that he could be paid, $45 an hour is fine with me, as long as the tribe thinks that it's appropriate. I would kind of put it would go into the level of what he is doing. If he's doing, like I said, if he's doing language tables or something like that, what does the person who normally would do a language table, what kind of compensation does he get out of that? So that would be an option there. And again, when I think of a language table as an example, that's something that would be a very, would be a mechanism for him to get himself inserted back into the community, which I don't think is a bad thing either in Mr. Taylor's case. Okay, any other questions on that, Mr. Adams?
No, I mean, I guess, yeah, I mean, I guess the one question that I have, Your Honor, is just to be clear. So, and perhaps it would be more appropriate to take this up when the tribe, maybe we can get into the specifics of it when the tribe moves forward with executing, the judgment. But I guess I'm kind of curious. So are you saying that Mr. Taylor, if Mr. Taylor pledged to the court that he was going to, work community service, then is he like alleviated or off the hook in terms of paying any restitution back to the tribe?
No, he's not. No,
Okay.
He's not. He has this is his debt. And until that debt is cleared, he has to pay this debt. One option of paying that debt is community service. That's all that is. It's not, does not alleviate the debt that he owes the tribe. He just has to, but one option to pay it, to take care of that debt is to perform community service.
Okay. Thank you, Your Honor.
Mr. Voorhees, do you have anything you want to add?
Judge, I would think it'd be appropriate to confirm by letter the nature of the community service agreement. And certainly the tribe would have to pick somebody to monitor that or work with Mr. Taylor on it. But I would expect it to be confirmed by letter, so there's some kind of written guidelines regarding that. And I think I'm in agreement with the terms as the court has otherwise set them out here. I do think the restorative justice idea is realistic, and there are people that could assist with that, but I understand the court's point that we may have to travel a path to get there. And again, we might have to have some formality to what is set up, and I would expect the tribe would have input and they have to agree to how that is. But I think it's realistic to consider that as a possibility down the line. So, thank you.
All right. Okay, Mr. Adams, can you turn this into an order, or do you need me to do that?
No, Your Honor. I mean, we can provide a new draft of the proposed order to Attorney Voorhees for his review, and then we can provide that. We can provide that to the court for your consideration, and maybe it makes sense to provide some broad parameters of what the community service would look like in the proposed order based on the statements that, what we've discussed, during this particular hearing. And then of course, I mean, the tribal court code allows for, a time period by which appeals can be filed and all of that stuff. I mean, I don't anticipate that, the tribe is going to file any type of appeal. And then once we get to through the formalities of filing the writ of execution, perhaps that would be, the appropriate time to get, really detailed concerning the nature of the community service and say what the credits would be for certain types of activities that Mr. Taylor, the services that he would provide to the community and the amounts that would be ascribed to those.
That sounds good. I like that. I like that idea. I do agree with Mr. Voorhees, though, at some point in time here, there needs to be a letter between the parties about what he's going to do and how he's going to be compensated. Although Mr. Taylor may be involved in one thing one day and maybe something else at a different time. Those adjustments need to be a little bit allowed for a little bit of fluidity in that. Like I said, for me, his language skills, that's a positive. But maybe he's going to want at some point in time down the road, to do something different. Again, allowing for his physical abilities, and we need to get past COVID too. We got a couple of things to go through. So anyhow, with that being said, Mr. Adams, I'm looking for you to write an order. Get you and Mr. Voorhees work it out best possible. If you're not able to come to an agreement, give it to me and then I'll take care of it from there. Okay, again, the court is finding Mr. Taylor responsible to reimburse the tribe for the 89 checks in the amount of $211,418.64. Mr. Taylor can perform community service to satisfy that portion of the judgment. Mr. Taylor needs to reimburse the tribe the amount of $22,080 for court attorney's fees and an additional $300 for court costs. Those need to be paid in cash. Mr. Taylor can do community service and he can work it out. The tribe and Mr. Taylor need to sit down and come to an understanding about what Mr. Taylor can and will be able to do as allowed to by the tribe and the amount of compensation for him for the tribe. And that's just what it is that Mr. Taylor can perform community service to offset the money that he owes the tribe. Doesn't alleviate or remove the debt to that Mr. Taylor has with the tribe. Okay. The other thing is Mr. Taylor is no longer eligible to run for political office because of this conviction. All right. Mr. Adams is going to draft the order, and Mr. Voorhees will review it, and then you guys will get it from me. Okay, with that being said, Mr. Taylor, I wish you well, health, and taking care of your grandchildren. Right now, the court's going to adjourn, and have a good day.
Thank you.
Court's adjourned.
Thank you, Your Honor.
Thank you.